right, mic check 1 2. Hello. Welcome. This is Just Human, episode 357. Sorry I haven't done a podcast in a while. There was Thanksgiving, and then there were snow days. My kids were out of school for like 5 days, 5 bonus days. I guess it wasn't that. It was a 5-day weekend for them immediately following Thanksgiving, thanks to some snow we got here in Southern Virginia, which anytime there's like an inch of snow in the morning or half an inch of cold rain or ice, school's closed. School's closed. Nobody knows how to drive. School's closed. Safety of the kids, which I don't disagree with, but it's fun having the kids home from school, and I know it's fun for them. I remember those days when I was a kid. I remember those days as an adult, and I'm happy for them. But mom and dad still got to work, and the kids don't quite get that. So after a couple of days of them being home, the third day of them being home from snow, it was kind of like, you guys can go to school. Like, what? It's time to go back. So, and they did. So anyway, welcome. This episode is going to be, I got some new news for you, some stuff I haven't done a video on yet. And then I've got some stuff I've already done videos on. So if you've been following, if you're subscribed to my YouTube or my Rumble page, some of the content in this episode, if you watch all the videos there, you've already seen, but I'm going to have some updates on them, and I'll have timestamps in the description here that show you where everything is. So if once you get to something you've already seen that segment, because I already published it in a video on YouTube or Rumble, then you can just skip to the next portion. All right. We have some great news. I'm still giddy. That's the right word for it. I'm still giddy over my most recent Comey video. Imagine that. I'm absolutely convinced that no, I shouldn't put it that way. That's a little bit over exuberant. I'm very confident that I have hit upon something of great significance in the Durham report and in an exhibit from United States v. Comey. And I think it ties a lot of things together and makes a lot of sense. And I think it jives with some recent news articles we've gotten. So if you haven't watched my most recent Comey video, which is either called Comey's Closeted Intelligence or the Counterintelligence Operational Lead that never reached FBI Director Comey, you should watch that video. In fact, maybe I should put it in this. I didn't send it out as its own thing on Substack. I may splice it in. I'm going to record some other stuff. I'm going to record some other stuff first, and then I'm going to see how long this episode is. I really want to get that out there. I really want my audience to dive into that video and give it careful consideration, what I'm getting at. Because what I'm getting at is a critical point in the Russiagate scandal that I think changes the way we look at it. Not completely, but it's this juncture, this critical point where I think things went in one direction and they could have easily gone in another. And I just think it just, anyway, I'm going to start retelling the entire thing now. All right. What I'm going to do here first is show you a black screen, because I'm super pro and you guys know that. That's why you're here. You don't tune in for the research and the nuggets and the dot connecting. No, you guys, I know you tune in for the black screen and the special appearances by the dogs, who are right here behind me. There they are. There they are. It's Hercules' turn with that particular bone. Athena is, I think she's moody. Athena, are you in a bad mood? Athena. I see that tail wiggling. Oh, there you go. Hey, Princess Blackberry. You got anything to say? You have anything you want to say? Can you speak? Can you speak? Uh-huh. Okay. Anything else? Yeah, you speak. You got pause. All right. I'll go back to the actual show. Roll this chair on the rug. Okay. If you like what I do here, if you like the dogs, you like the black screens, you like the advice on gourmet coffee, visit my link tree. There you will find all the places to follow, all the places to watch, all the places to listen, and all the different ways to support. Guys, if you have not gotten Christmas gifts for all the people that you're going to get Christmas gifts for, my links are a good place to go. You can buy something sweet or some soap over at Benson Honey Farms. They have excellent products there. Food Lake Products, they also have excellent food and seasonings and sauces. It's chili season. Great place to get chili. I promise you, you will not look. You just buy a bag of chili from them, okay? You buy one of their chili options. You buy a pound of ground beef at the store. You brown the ground beef. You throw it in a pot, a saucepan, whatever you want to call it, with the chili in there. You let it all heat up. You want to do it at a low temperature. You know, don't rush it. Don't rush it. Let the meat absorb that flavor and then serve. Everybody will love it. Food Lake products are fantastic. I love everything I've had from there. They taste great. They're easy to cook with. It's so good. Manly Cans is another option if you need a gift for that manly man in your life, or, you know, a female who likes some of these products. You can go to Manly Cans, use my affiliate link, make a purchase over here, pick out a can that suits that manly man, and you're done. Christmas shopping done. The Dapper can and the Bearded Man can are my favorite, naturally, but I like all their cans. I've had a variety pack from them. I've gotten some samples from different things, and it's good stuff. There's a lot of options out there when it comes to like these gift baskets for men. That's basically what we're doing here at Manly Cans, right? Gift baskets for men. But at Manly Cans, everything's just a little bit better. Like the stuff, the quality of the items that are in the can are above the average of what you find in a gift basket. So great place to get a gift. But if you just want to contribute directly to the show, thank you very much. Some of you have bought me coffee lately. I appreciate it. I am going through that coffee as I'm going through all of these documents from cases. Thank you for everybody who's buying me coffee at Ko-Fi.com. If you want to be part of the core support for what I do here, justhuman.substack.com. Sign up for a paid subscription there. Everything on there is free, so you can just subscribe anyway. Everything on there is free, and you'll get notified in your email or on the Substack app that I've uploaded something. But a paid subscription there, $7 a month, buys me a cup of coffee a month, and contributes $2 to the Pacer Fund. Think of it that way. If you like the documents I go through, if you like the court cases I keep track of, if you like the research articles I do, which I am very proud of this most recent article I've done, and I hope you will take the time to read it or take the time to listen to me read it. If you like me doing that kind of thing, it's that $5 cup of coffee a month and the $2 to the Pacer Fund that make that happen. So thank you, everybody who contributes and supports the show. I really appreciate you, and I wish you a Merry Christmas. Thank you for all your support. Okay. And I really do. I'm just going to give you guys a heads up. In this video, since I'm splicing in a couple of videos I've already done from YouTube and Rumble, I'm going to self-promote a couple other times in this podcast. So sorry if you get tired of hearing it, but it's already recorded in these other shows. So, all right. Let's see. Where do I want to start? Let me pick out the start point. All right, got an update for you in United States v. Cole. That is the case of the J6 pipe bomber, who we now know was Brian J. Cole Jr. And I've seen a lot of theories going around about how it's not really him. He's a patsy, blah, blah, blah. I'm sorry. Look, I'm sorry. I mean, no offense to anyone, but these alternative theories about it being someone else are just silly. To put it very politely, they're silly. To put it a little bit less politely, they're absolutely ridiculous. Okay. The evidence that they have on this guy is substantial. We have his vehicle in the vicinity of where the pipe bombs were placed within minutes of him appearing on video. We have his vehicle, license plate was photographed, and it's his vehicle that the license plate's on, and it's on camera minutes before he then shows up on surveillance cameras in the neighborhood walking around to where he placed the pipe bombs. They've traced his entire route. They have his cell phone during the exact time that he appears on camera in that area where he planted the 2 pipe bombs. They have his cell phone connected to towers in that area multiple times. They have his bank account records and all of his purchases, not all of them, but the purchases that are relevant to the case. They have those nailed down. We're talking about dozens of purchases across 2019, 2020, and then January of 2021, because he continued purchasing bomb-making materials post placing the bombs. They know what store he got it in. They know they traced the exact wire, the exact battery connectors that were sold to the Home Depot or the Lowe's or the Walmart, whichever one it may be, because he made purchases at all those stores, or this battery type store. Can't remember what it's called. They traced the exact lot number and production date and all of the things right down to that specific packaged battery connector, where it was distributed to, where it was sold at, when it was sold. They have all of this stuff tracked. It really doesn't get much better than this. The only way it could possibly be better is if they have his DNA on these bomb making materials, which maybe they'll end up with that. I don't know. I haven't seen anything saying they weren't able to get any DNA off of these bombs. Maybe they got some DNA off of them, and now they have him in custody. They're going to get a search warrant for his DNA, and they're going to match up DNA profiles, or at least partial DNA profiles. They got the guy. Just celebrate it. This stuff going around that it's not him, it's the Capitol Police woman who is falsely maligned and is going to own she's either going to own the Blaze, or she's going to become millions and millions of dollars richer thanks to the Blaze. It's disinformation. And a lot of it is coming from the same crew, the faux FBI whistleblowers, the people like Steve Baker, who is not an investigative journalist. He's a misinformationist and disinformationist. I'm gonna stop myself. Anyway, there's just no basis to go speculating about it being someone else other than him. Now, maybe someone else involved, dude. Of course, yeah. There could definitely be some other people involved in putting this kid up to this. I shouldn't say kid. He's not a kid. Putting this guy up to this, and I think what we're going to find out is that this guy has some neuro issues. He's neurologically atypical in some respect. Don't know how much, but I think that we're probably going to learn that I'm just going to keep it at that, neuroatypical, and that he's trans or effeminate, hence the way he walked, and some people thinking it might have been a woman walking. I think he's effeminate. All right, which there's nothing wrong with being an effeminate male. Just like there's nothing wrong with being a bit of a masculine woman. It's just, anyway, that gets me off on something else. So I think that explains a little bit about what his appearance in the video and the way he walks. I think we're going to find out he's more of an effeminate person, possibly trans or curious. There's been a furry community he looks to have been a part of online, some furry forums. There's been some other social media profiles of his that have been dug up, and I don't know that I haven't seen anything that says that he is Antifa, but I think it's highly likely that he is ideologically mixed up. And I don't know if he was put up to this or if he has a difficulty. How do I want to say this? We're talking about a 30-year-old man or something around there that lived at home with his parents, and his parents appear to be radical leftists who run a business that profits off of people who have been detained by ICE and offers them legal services and uses some of the most not so above the board attorneys and law firms to do these things. There's also some evidence that his family was in a lot of financial trouble. There's a lot that's going to unfold from this. I do wonder if we're going to find out some connections to his family was in a very bad state and was very upset about Trump winning. And so maybe this person who is neuroatypical and has a lot of bad influences in his life and is living in his parents' basement or something like that, had a very twisted perception of the world and decided to do a twisted thing. It does appear by his purchase pattern that he was motivated by real world events to start getting into bomb making, such as the 2020 riots. And for whatever reason, either he did make attempts to place explosive devices and we don't know about it. That's something that I'm kind of wondering about. With all of his purchases, he purchased enough material to make more than two, I should say, of these pipe bombs. Yet we only know of 2 that he placed. We may end up learning that he placed more. They just didn't go off. Or they did, and investigators haven't tied him to those events. That might be more likely than not. That this is not the only time that this guy went out and tried to do something like this. The purchase patterns indicate that we have like a 2-year record, or at least a year and a half, of this guy going down the road of building these devices. And the purchases line up with some real world events that really makes me think he was trying to participate in that sort of behavior. So anyway, I've just given you some of my thoughts that are on my mind about the case. Let me tell you what's going on with it. So since he was arrested and detained, he's been sitting in jail in DC. Okay. He's had an attorney assigned to him. There are leaks from the courthouse saying that he admitted to planting the bombs to FBI agents and that he believed the election was stolen. I already went on in my other video. I already talked to you guys about what I think about some of that. And I'm going to reiterate here. I'm not going to go back into it. I just want to tell you that CNN story that ran around the time he was arrested, stating that Cole had admitted to investigators that he believed the 2020 election was stolen. A lot of people jumped on that. The left-wing media, of course, did, because they believed that they could use that to reinforce their narrative about J6. Okay, remember, each side has their own narratives, especially influencers and media outlets. They have their own narratives about J6, and they are going to be doing everything they can to reinforce those narratives and defend those narratives that they have been pushing on their audience for 5 years. Left and right. The problem is that generally people on the left and people on the right do not have a coherent narrative about J6. They have a political narrative that suits their political ends and their clickbait, outrage bait ends or goals. But they don't have a coherent story of J6, one that makes everything fit. And I think both sides are very, very, very threatened by the arrest of the J6 pipe bomber. Their narratives are under threat. And that's why you'll see on the left, they're going to work hard to try and highlight anything that makes it seem like Cole was MAGA or was trying to help Trump or something like that, even though it doesn't make any sense. Doesn't matter if it doesn't make sense. What matters is a 30-second soundbite or a viral headline that people will peripherally absorb and get the notion that Cole was trying to help Trump or that he's some sort of Trump-aligned agitator, whatever. Same thing on the right. The right is going to try and portray him as Antifa, which he may be, but we don't know. They're going to try and do everything they can to say that he was actually secretly working for the FBI, or it's not Cole, it was a patsy. That's why there's all this disinformation. The whole reason the Blaze got duped into running that story, which I'm being kind to the Blaze. I hope they were duped. I hope they realized they were duped. And I know that they gave a very weak retraction of the story like 2 or 3 days after this arrest. It's not enough. They need to disown that story and disown Steve Baker. But Steve Baker and Kyle Seraphin and Stephen Friend and like these other faux FBI whistleblowers and these people who are trying to put out there that Cole is a patsy or it wasn't really him or whatever, they're putting out disinformation in order to protect the narrative that they have been harping on for the past 5 years, which is that FBI did J6, which is bullshit. And this CNN, for their angle, they really push this right here. But this is the most important thing about that news article, guys. The most important thing that CNN got in their leak about Brian J. Cole is that he talked to investigators. He didn't shut up. He didn't get arrested and say, lawyer. Nope. This guy spent hours with FBI investigators and made multiple statements. That's the most important thing in the whole story. Later, like the next day, it comes out that he admitted to these investigators that he planted the bombs. Or maybe it was later that same day. We don't know that he actually did. We don't know that he did. Okay? We don't know if any of these leaks are true. They may all be lies. It may be lies that he said the 2020 election was stolen, and it may be lies that he said he planted the bombs. We don't know yet. We'll find out. But while he's been, that's the next story. Oops. But while he's been in jail, he's gotten defense attorneys. One of them is Charles Robert Jones. Who's Charles Robert Jones? Well, he's not a criminal defense attorney. That's who he is. Actually, did I get the wrong thread? There we go. Okay. I got not Charles Jones. Sorry, I totally messed up. Charles Robert Jones is the prosecutor who filed appearance on December 9th. He has prosecuted a bunch of murder cases, witness intimidation cases. Looks like he's focuses violent crime in D.C. He's been there for several years, but now he's in the national security section. And we know that DOJ is looking to prosecute, is investigating whether or not they can prosecute Brian J. Cole on terrorism charges. Right now, it's transportation of explosive device, planting of explosive device, those things, and he's being held without bond. Okay. And Charles Robert Jones looks like he's been put in charge of prosecuting this case. It's interesting to me. I don't know if it's just because he's like the most senior assistant United States attorney, and it doesn't seem like the right fit. I could be totally off base here, but I looked at Charles Robert Jones' experience and what other cases his name appears on in DC, and they're like all gang violence, murders. The most recent conviction he got was in November, and it had to do with a guy who went and intimidated a witness that, and I believe they had witnessed a gang murder, if I remember right. So I find it interesting that he's the guy on this case. Maybe it's because he's the most senior and experienced, or maybe it's because there's something going on here with intimidation or violent crime or something. Now, of course, planting explosives is a violent crime, so I'm not saying that. I'm just noting his experience. I didn't find any other case where he had dealt with terrorism or explosives or any political cases. Anyway, so Brian J. Cole. Now we go back to him and who his counsel is. He retained counsel, and that counsel is John M. Shorman. And John M. Shorman is not a criminal defense attorney. He is one of the two stars at HDR Law Firm, and HDR Law Firm is Human Dignity Rights Law Firm. And they are a left-wing, what's the word for it? Criminal justice type law firm. They focus on going after government agencies like ICE and DHS, and they focus on going after police departments, and even there was a case where they sued an actual police officer over an arrest, and they're that type of law firm. Okay, I'm not saying that people aren't disenfranchised ever, or that people don't need these types of lawyers or those types of lawsuits. It does happen, but I just don't get the most. I just right now, my first impression of them is that it's they're a grievance law firm. Okay, so that's who he's retained, and that seems an odd choice when you're being charged with planting 2 pipe bombs in Washington, D.C. and possibly being charged as a terrorist. Those are not the type of cases. They're not criminal. They don't do criminal defense. So it's weird that those are his defense attorneys, and they're not experienced in this kind of thing. But they were there for him, and he did not enter he had his initial appearance, but didn't enter a plea. December 15th is when his bond hearing was set for, okay? And his bond hearing is where he's going to enter a plea, and they're going to let this guy out on bond while they wait for the case to go to trial, right? Well, Charles R. Jones, the prosecutor, made a filing saying that they want to postpone. Both sides do. And I made this short thread, and this is like the main thing. It looks like the J6 pipe bomber is going to spend Christmas in jail. Brian J. Cole Jr. will spend Christmas in jail. Prosecutors, at the request of defense counsel, who, remember, they have no experience in criminal court, filed a motion requesting a continuance of the detention hearing currently set for December 15th. They want it moved to December 30th so they have time to review the significant amount of discovery that they've been provided so far, which they call it the significant amount of discovery that they've been provided so far. But as I'm about to show you, they haven't been provided all the discovery. I think they've only been provided what was used to arrest him. The stuff that these malcontents and disinformationists are telling you isn't enough and shows that Cole is a patsy. Yeah. The government doesn't oppose the continuance. And so the parties jointly request from the judge that the detention hearing, which is where his bond, he might have gotten the chance to be out on bond, be moved to December 30th. So he's going to spend Christmas in jail. What I've noted about here is that it might be worth noting, I should say, is that the defense transmitted this request for a continuance through the prosecutors. And I think that's worth noting because, again, they're not criminal defense lawyers. They're grievance lawyers. And it was granted. So it's December 30th will be the next time that December 30th, if I can speak, will be the next time Brian J. Cole is in court. Since the judge set this order, a couple more filings have come in. This unopposed motion for a protective order for the discovery, which again is being jointly filed. Prosecution's filing it on behalf of both parties, the prosecution and the defense, saying they don't oppose this protective order. It's just a generic, just basic protective order for the discovery materials. And what protective order means here is that, hey, this is the discovery in the case. You can only share it with these people. It has to be kept in this place. You can't give it to the media. You can't give it to friends and family. It's for the defendant and it's for his counsel. Here's how we're going to go about conveying it to him. Like it's pretty basic, okay? And the judge agreed to it. It's like, all right, that's the order. This is what we're going to do. But again, it's another motion that the defense filed through the prosecution. And I don't want to read too much into it, but if we see this continue, it looks to me like the defense is, they're out of their depths here. I'll say that they are out of their depths because I can't find any experience that they have being criminal defense attorneys. So just naturally, they're out of their depth because this is a criminal case. Much more so, it's a high-profile political, possibly terrorism case. So obviously they're out of their depth. Maybe they're just his counsel for now. Maybe they're his counsel because of the type of business his dad is in. And maybe he knows these guys. And so this is the type of law firm he goes to because his dad's bail bond business, that's their history of using grievance lawyers like this to sue DHS, sue police departments, all of those things. So in that way, it makes sense that this is who they reached for as defense counsel. But not only is the evidence against them, let's assume that what was reported about him making statements to the media is true. Let's not remember, leaks are real, news is fake. Let's just say that the stuff about him admitting and stuff about him believing the election was stolen, let's set that aside, okay? Let's say we're not quite sure that that's being reported accurately, okay? Because that's fair enough. But let's take this one line. Cole spent hours with FBI investigators and made multiple statements. If you wanted your client's statements that he made to law enforcement tossed, what type of law firm would you go to? If you wanted to accuse law enforcement of making missteps, of violating your client's rights, and then through that angle, get evidence dismissed, get your client's statements dismissed from the case, thrown out, what type of law firm would you go to? Yep. So I also think, not to get too far ahead of myself, I also think it could be this kid. I shouldn't call him a kid. This guy gets picked up, starts rambling off to FBI investigators before anybody can get him to be like, no, I gotta talk to I need an attorney. And then once he gets an attorney, these attorneys are like, oh, oh no. Why didn't he shut up? When the cuffs go on, you shut up. So that's your update. Brian J. Cole's going to be in jail over Christmas. December 30th is the next time we expect to see him in court. Of course, a filing could change that. It's a developing case, but I'm going to keep tracking this one. This is a case that I'm going to track very carefully. This is going to be one of our main things for the foreseeable future. It's too early to say whether it'll go to trial. I have my sense is from the way it started off, it won't. And they've got this guy dead to rights, and his team's gonna end up. I think he's going to end up switching counsel or bringing on criminal defense attorneys, and they're going to be trying to get a plea deal for him. I also think they're going to motions to suppress evidence. I think they're going to go after law enforcement for whatever. I don't think they're going to be arguing they got the wrong guy. I think they're going to be arguing cops went about it the wrong way, fruit of the poisonous tree. This kid's a victim of social pressure. Yeah. I think we're going to see stuff maybe along those lines, but we'll find out. So, all right, stick with me as I go through that case. Now, in related to BLM news, the next thing I want to talk to you about, United States v. Dickerson. This is BLM embezzlement case out of Oklahoma City. Hey folks, I got a quick update for you regarding the unsealing of Epstein and Maxwell grand jury material. As you probably know, Congress got off of their asses recently and passed an act to unseal or disclose all of the Epstein and Maxwell material that DOJ has, and that would include the grand jury material in the 3 federal cases that they brought against those 2 individuals. 2 cases in the SDNY, Epstein and Maxwell, and then the older Epstein case down the Southern District of Florida that resulted in a controversial plea agreement and non-prosecution agreement, I should say. The plea agreement was with the Florida prosecutors. The non-prosecution was with the federal. So 3 different judges, the same ones. Well, no, that's not true. 2 of the same ones that DOJ went to this past summer, and a different judge in Southern District of Florida have now approved the unsealing of those grand jury materials. And I'm going to take you through their orders very quickly because they're pretty short and just kind of give you a heads up on what to expect from this unsealing. Thank you for tuning in. If you like the content I do, visit my link tree or the links in the description of the show. And there you'll find all the places to follow me, all the places to watch the videos that I make or listen to my podcast, and all the ways to support the show. Thank you to everybody who's made purchases at these affiliate accounts. It's Christmas time, so you can go over there to Benson or Bootleg or Manly Cans and find a gift for someone you care about during Christmas. Ko-Fi.com is how you keep me caffeinated. But Substack, justhuman.substack.com, is the best way to support what I do. $7 a month. Keeps me caffeinated, and it keeps my Pacer addiction going. I do have a new video over there on the Comey case and a new article that I really hope you would find the time to read. I'm very proud of that article. All right, let's jump over to the Epstein stuff. So there's United States v. Epstein out of the Southern District of New York, the SDNY. And that order is just 4 pages, and it basically just, Judge Behrman is who it is. And he just says, yeah, I got this new motion. It has to do with the Epstein Files Transparency Act, and here's the legal standard that I have to deal with, short discussion part, grand jury materials, and then the protective order that was already over some of the material, and the victim's rights, which he mentions here, like, you cannot do this at the expense of privacy or safety of the victims in this case, which we, of course, all agree with. And then he signs it. It's unsealed. So when they make this, when the judge grants this, the judge doesn't have the material, which he had access to it, which I'll get to in a minute. But it's DOJ who's actually going to do the unsealing. They're the holders of the material, but it's ordered sealed by the court. Per federal rules of criminal procedure, grand jury material is sealed and remains sealed unless there's an exception to it, which we went over in my threads and videos from the summer when DOJ first tried to unseal this stuff. United States v. Maxwell, SDNY, again, this order from Judge Engelmeyer, who's the same judge, and Berman was the same judge in Epstein who dealt with the initial DOJ effort this summer. Engelmeyer was also the judge who dealt with it over the summer. His order is 24 pages long. And that is because Maxwell is, one, still alive and in custody and has been trying to get her case appealed and trying to get a new trial. SCOTUS denied her most recent attempt to get them to look at her case. There's not much hope, I don't think, for Maxwell getting her conviction thrown out, getting a new trial. I don't think there's, thankfully, I don't think that she has a prayer of that happening. In fact, I think that if there was a new trial, she might get a more severe sentence than the 4 decades that she got, or whatever it was, 20 years. Yeah, 20 years, I think. But his order is 24 pages because he goes ahead and deals with all of the ins and outs of the act and the legal issues and the case law. And he drills into the Transparency Act itself and exactly what it says has to be unsealed and what DOJ is asking for. And he puts in a lot of work on this because he knows this is going to be appealed. So in these other guys, Behrman, he's not worried, I don't think, about the Epstein estate appealing his order here to unseal the grand jury materials. And the reason he's not worried about it is because it's already, pretty much all of it is already public anyway. In Maxwell, pretty much all of it is already public anyway as well. But he knows that the Maxwell counsel and Maxwell herself is not going to be pleased about this. So he is going into the details and setting up for the appeal that's going to happen so that his order will survive that appeal. The bottom line is it's going to be unsealed at some point. This one may get delayed, though. I would not be surprised if we see DOJ release the grand jury material from this case and the Southern District of Florida case before the Maxwell stuff comes out. But you shouldn't be too bothered about that because, like I said, you already have it. You've already seen it, especially if you, like me, or possibly with me, paid attention to the trial. Now, here's the more interesting one. In fact, it's the interesting one, I think. It's the case out of Southern District of Florida back from when Epstein got on the federal authorities and state authorities in Florida's radar back in 2005, 2006. And they impaneled a grand jury to take a look at him in 2005 and in 2007. And that resulted ultimately in the plea deal with the state prosecutors and the non-prosecution agreement with the federal government. This guy's order, it's a different judge. His name is Rodney Jackson, maybe? Rodney Smith. So his order is only 2 pages. There's not much for him to deal with here. This is a grand jury that happened 2 decades ago. And because of the Epstein Transparency Act, he says, yeah, because of that act, I can unseal these records, so I'm ordering them unsealed. That's basically it. He cites a couple cases that apply here, but simple. Done and ordered. They're going to be they can be unsealed. Go ahead, DOJ. What makes this one interesting is that we've never seen these materials, and no judge has taken a look at them. And in a short thread I did on X, where I went over their orders just real briefly, and I went back and pulled in some of what happened over the summer, which if you were with me, if you've been following me since then, you know I went into the details of those DOJ's actions to get the grand jury material unsealed over the summer. What I have here is that, and what you need to know going into this, is that a significant majority of the SDNY material is already public, but the SDFL material hasn't been looked at. And we know from the actions this summer, what ended up happening, if you remember, is that the SDNY judges already took a look at the grand jury materials. That was one of the things that they had to do as they were considering whether or not to unseal them. both Behrman and Engelmeyer ordered the DOJ to file the grand jury materials under seal on the doc with them. I think it said on the docket, but I don't know if it was actually on the docket because we know we had the Pacer hack, and that's I could rant about that for a while. And the judges, when Engelmeyer and Behrman, when they looked at the material, they found that it did not contain anything truly revelatory. In the Epstein ruling, the judge said the government's complete information trove, which is 100,000 documents, would better inform the public about the Epstein case than the 70 pages of material that is currently sealed related to the grand jury in this case. There's 56-page transcript from the FBI agent's presentation to the grand jury back in June of 2019. There's a 14-page transcript of the agent's re-presentation from the grand jury that happened on July 2nd, which resulted in the superseding indictment of Epstein. There's a PowerPoint exhibit and that was shown to the grand jury, and there's a call log, like a phone call exhibit that was shown to the grand jury in 2019. That's it. That's all the stuff that's there. There were no victims that testified. There were no witnesses. There's no, if I remember correctly, it was like a 90-minute or an hour grand jury presentation, maybe. Very, very short. It's 70 pages, and almost all of that material is already public. Let me see if I can get this image to load. I'll refresh this right here. Jump me down. Right. It is jumping around. I made it mad. I criticize Pacer, not you, thread reader. There we go. Okay. So the Epstein, I wouldn't expect anything from the Epstein, SDNY stuff. Nothing new there. Nothing revelatory. And then with the Maxwell material, this is the one it wouldn't load on this page. It wasn't an investigatory grand jury with Epstein or with Maxwell. So they weren't putting out search warrants or subpoenas or hearing from witnesses or victims. And then a significant and compelling reason to reject government's position in this litigation, the judge ruled in Epstein, was that the government itself has already assembled a trove of Epstein documents, interviews, and exhibits. And the government is saying it committed to be transparent and show these materials to the public, yet they're coming after 70 pages from this grand jury when they have 100,000 pages themselves that would better inform the public of what happened in the Epstein investigation and what they found. And in Maxwell, it was a similar thing. They got the grand jury materials. Judge Engelmeyer did. He did a review of them. I did multiple threads on this and some videos on it over the summer. They're on my Rumble. And he took a look and he said, look, this grand jury was not used for investigative purpose. The evidence that was put before the Maxwell grand jury is, with very minor exceptions, already a matter of public record. And one of the ways it became a matter of public record is that Maxwell actually went to trial. She had a multi-day trial where the same evidence was presented and more. There were victims that testified. There were exhibits shown. There's nothing new in this material. The court's review of the unsealing grant, the court's review, the court's review confirmed that unsealing the grand jury materials would not reveal any new information of consequence from United States v. Maxwell. And there were no revelations in the material of new crimes or third-party conspirators or victimizers, no new victims or locations or new evidence. Nothing that anyone familiar with the Maxwell case would find compelling or revealing. And as the judge put it, there's no there in the Maxwell material. And remember, it was over the summer and leading up to the summer where you had a ton of pundits and clickbait, outrage media, talking heads and outlets that were complaining about how DOJ is, and it was on the left and the right, complaining about how DOJ is trying to hide and protect third-party conspirators, and they're concealing this. Bondi is concealing this stuff. Kash Patel is concealing this stuff. Bongino is lying. He's a turncoat. All of these things, and none of it's true. they were alleging, these people, that the Trump DOJ and that these judges are trying to hide victims and evidence and third-party conspirators. And as Cash and Bongino tried to tell people, guys, there are no uncharged third-party co-conspirators and victimizers that's revealed in these materials. It's all conspiracy theory nonsense, but it's very popular. And unfortunately, people are more prone to believe nonsense these days and memes than they are to believe actual evidence and documents. However, the SDFL grand jury materials is something different. There was no in-camera review of those materials over the summer. No judge took a look at them. DOJ didn't file them. They didn't have to. They weren't ordered to back then. And it wouldn't have helped anyway, because the judge in the SDFL case back then, her hands were tied. And those same clickbaiters, those same people who were complaining, lied about this judge. And they insulted her and criticized her, saying that she was protecting co-conspirators and she was this deep state, crooked judge, whatever. So many people lied about this judge when the government's own motion conceded that she could not unseal the materials. She did not have the power. No Florida judge could unseal them, given the motion that DOJ filed, because there was no exception to Federal Rule of Criminal Procedure, what is it, 63E or whatever. I went over it in a thread back then and in a video, and it's very easy to understand. If I recall correctly, there's like 6 exceptions or 5 exceptions that have to be in play in order for a judge in that district to unseal grand jury materials, and none of them were. None of them applied. And DOJ conceded that in the motion, and they said, we know it's going to be denied, but we're going ahead and filing it in order to preserve it for a future appeal, which they ended up not having to do because the Epstein Transparency Act. So anyway, no one's looked at this grand jury material from Florida except for DOJ. There might be something new there. There just might be something new there. And it bothers me talking about this again. It re-aggravates me. Because you had a very simple situation that was very understandable, even to me. And we went through it on my show and in threads, and completely understood where DOJ was coming from in that case, where the SDFL judge was coming from, understood the precedent that was in play and the Federal Rules of Criminal Procedures. And we're just like, yep, DOJ made that filing. They're preserving it for appeal. Maybe something will happen later down the road. And then you turn on your TV or you go online and you look at these outlets and pundits who are just absolutely lying to their audience about the judge and about what happened in that case. Many such cases, right? Many such cases of that happening. So we'll see if anything is new, but just like I told you over the summer. Where is that? I'm going to get that memo. Where is that Epstein memo? I'm going to find it. This memo right here that came out on, what was it, July 6th, July 5th, something like that, that first leaked through Axios, but it was published on a DOJ on justice.gov, so people knew it was real. It said, look, we did a systematic review and we found there was no incriminating client list. There was no credible evidence found that Epstein blackmailed prominent individuals as part of his actions. We did not uncover evidence that could predicate an investigation against uncharged third parties. Consistent with prior disclosures, this review confirmed that Epstein harmed over 1,000 victims, and each suffered unique trauma. Sensitive information relating to these victims is intertwined throughout the materials, and this includes specific details such as victim names, likeness, physical descriptions, places of birth, associates, and employment history, and all of that stuff should be redacted. One of our highest priorities is combating child exploitation and bringing justice to victims. Perpetuating unfounded theories about Epstein serves neither of those ends. And yet you watch, people will continue to do it. And one of the reasons why I'm telling you now, you should not expect these huge revelations regarding a client list or third-party co-conspirators or something like that as relates to the sex crimes. The reason you should not expect some sort of revelation about those things is because DOJ already looked at it. They have the 100,000 plus documents. They've already went through the review, and they already reached the conclusions here in this memo, and I do not expect these conclusions to change. I also don't expect people who have been clickbaiting and lying to their audience about this material and creating conspiracy theories that are just, unfortunately, far more popular than the truth. I don't expect them to stop doing that either. So I am interested, though, in what comes out, especially if there's something new in this. And the one thing I am most looking for, I don't know that it's there, but the thing I am most interested in seeing is if there's any sort of draft subpoena to have Trump testify because he was an informant. And I just want to know if there's going to be anything in this that gives us a hard document showing that Trump talked to the FBI about Epstein's criminality. May not be there, but it sure would be fun if it is. Hey, folks, I got a quick update for you in United States v. Arnold. That's the North Texas Antifa Cell case that came about after a group of individuals, some like 15 individuals, attacked the ICE facility, the ICE detention facility in North Texas, outside of Alvarado. And I think it's called the Prairie Land Detention Center. And this case is really interesting because it's the very first time that an Antifa cell has been charged as a terrorist group and has been hit with terror-related charges, rioting, attempted murder. It's quite a significant case, and it could be a landmark case as DOJ goes into legal battle against these Antifa cells that have propagated across the U.S. and have international ties. In my last video that I did going over this case, it was 3 weeks ago. Yeah, it was this one right here. When I went over this case, I mentioned how on the same day, the very same day that a superseding indictment was rolled out in this case, the U.S. State Department designated 4 Antifa groups in Europe as foreign terrorist organizations. And that can't be a coincidence that this landmark, super important case, the first time DOJ has brought terrorism charges against an Antifa cell and is naming them as an Antifa cell. I believe it's the first time Antifa has been defined by DOJ in a court filing. Same day they drop that, State Department designates these 4 Antifa groups out of Europe. So there's going to be a link to this video right here in the description here. I'm going to put it on screen somewhere. So if you never saw this one, you should definitely check it out because that's going to be an overview of this case. There's 9 defendants, and there's 6 people who have become, well, they flipped, I think. I think they're cooperating witnesses. They may end up getting charged for something. There's more cases than just this one. We know that from this article that came out around the time of the first indictment. And it was around the first indictment. The original one that charged, I think, just 2 individuals at first. Then they ended up adding a bunch more. The FBI at that time had made over 20 arrests tied to this case and related Antifa networks. And after I get done presenting this to you, I'm going to go search around on Pacer and see if I can find any other Antifa-related DOJ cases that are going on, whatever district they're in, whether in North Texas or somewhere else. So if you want to contribute to my Pacer fund, those searches on Pacer cost money, and getting documents off of Pacer also costs money. It's so many cents per page. So if you would like to contribute to that, I really appreciate it. Over you can find my link tree, and there you'll find all the places to follow me, places to watch, listen, and all the ways to support. You can contribute directly to my Pacer Fund by going to ko-fi.com, buying me a cup of coffee, or going over to justhuman.substack.com. Monthly subscription there contributes a few bucks to my coffee fund and a few bucks to my Pacer fund. Thank you very much, guys. Everybody if you're a paid subscriber over at Substack, which everything on there is free, you don't have to be a paid subscriber to get my latest article, which I'm extremely proud of. I put a lot of work into it. Or to watch my videos or listen to the podcast that comes out from Substack. You don't have to be a paid subscriber to get any of those things. But those of you who are a paid subscriber, you are the core of my support, and I can't thank you enough. Okay, so the update I have for you in this case is that there is a new superseding indictment. And somewhere around here, I have a bumper sticker that a fan of the show gave me that says, "I heart superseding indictments." And I stored it away. I put it inside a book to keep. I was traveling. I met him at an event, and I shoved it in a book that I had with me, and I haven't found it since. I put it in there to keep it safe, while I was traveling, and I have it somewhere, but I gotta find it and put it up somewhere where it's visible for this show. I thought about it when I saw this superseding indictment. So I love superseding indictments. And this one, it doesn't add a whole lot to what we already had, but it's still a superseding indictment, and it does make a significant change. And the defendants, these 9 defendants, I promise you, they think it's pretty damn significant that there's been a second superseding indictment. We're 30 days out from trial. This is supposed to go to trial like third week of January, I think January 20th, which surely it's going to be put off. Surely it's going to be delayed again. But in this superseding indictment, the second in this case, there's been a small edit to a mention of a co-conspirator. It's Nathan Bowman is the co-conspirator's name, and he's one of the uncharged people that was originally part of the group that was going to be charged, and he was there that night as they attacked the ICE facility and ended up shooting an Alvarado police officer and shooting at ICE personnel. But he was originally shown in this as, it said right here, Nathan Bowman, a co-conspirator not named as a defendant herein, who was one of the rioters vandalizing government property, is who the Alvarado Police Department officer, when he arrived on scene and stepped out of his police cruiser, that's who he began issuing commands to. But the change, the small edit that they've made, is that it now says that when that officer stepped out of his police cruiser and began issuing commands to a rioter who had been vandalizing government property, it doesn't name the rioter. And so that little edit, this is a minor change in the superseding indictment. No, it's not super exciting, but there is something you can kind of learn here, okay? He's not charged. So it could be, it could be not near as exciting, and that it's just that the prosecutors weren't 100% sure that it was Bowman doing the vandalizing and that the police officer was giving commands to. Because after all, they're all wearing black bloc, which is they're all dressed in complete black, and they got their face covered with a black mask, and the purpose of it is to hide their identity. So, in order to make, specifically for this potential reason here, to make it more difficult for law enforcement to identify them and then charge them with specific acts. That's the whole reason that Antifa wears black bloc. So it could be that prosecutors aren't 100% sure it was Bowman. But the more exciting idea, in a way, or intriguing, is that maybe they don't want to articulate in the indictment in the case that Bowman, who is uncharged, was committing a crime of vandalism to government property. And so they don't want to put that in a filing, that he was doing this. And it could be something that his defense team asked for. Like, hey, in that superseding indictment, my client is described as committing a federal crime. Could you Take that out because you're not charging him with committing a federal crime. And if you leave that in, it seems like something that could be used against him later. You're defaming my client, whatever. And I think that's probably the reason. I think that Nathan Bowman is one of the people who is cooperating. There's a number of them, and we know from a filing a while back, right before the superseding indictment came out. It's like right in here somewhere. The government made a motion or put out a notice. I think it might be this one for it to be regarded as complex. I think it might be this one, where they said, we're offering a deal to everybody in this case. If they want to cooperate, we're offering them a deal and they won't be charged in the superseding indictment. But if they don't take up the deal by such and such, there'll be a superseding indictment. They told the judge that, and sure enough, a couple days later, it came out. So I think he's one of those. And all right, so here's the major update. The major update is that they've brought in forfeiture. DOJ has. And in fact, it'd be better if I just grab the filing. They've added a forfeiture notice here, which means the government's going to take their stuff. You get convicted in this case on one of these counts. Upon conviction, we are taking all of your stuff that had anything to do with these crimes. And remember, they're being charged as terrorists. So their bank accounts, vehicles, whatever, anything, any property, real or personal, which constitutes or is derived from proceeds traceable to the offense, assets, foreign and domestic, of any individual or entity or organization engaged in planning or perpetuating any federal crime of terrorism, which is charged here, and all assets, foreign or domestic, affording any person a source of influence over any such entity or organization, acquired or maintained by any person with the intent or purpose of supporting, planning, conducting, or concealing any federal crime of terrorism, charged here, derived from, involved in, or used or intended to be used to commit any federal crime of terrorism. Upon conviction of these offenses in these alleged accounts in this second superseding indictment, under these statutes, these defendants, Cameron Arnold, Autumn Hill, a.k.a. Zachary Evans, Benjamin Song, Savannah Batten, Bradford Morris, also known as Megan Morris, it's a trans person, Maricela Rueda, Elizabeth Soto, and Inez Soto shall forfeit to the United States any explosive materials involved in, or blah, blah, et cetera, et cetera, et cetera. And they list these out for each of the offenses that are terrorism related, in which there can be this forfeiture applied. And it gets super interesting because of the possible connection to those European groups that were designated as foreign terrorist organizations on the same day the original, actually, this is the domestic one. Where's the one? There it is. These European-based Antifa groups that were designated as foreign terrorist organizations on the same day the original superseding indictment came out in this case. And I think it's highly likely that there is some connection, if not to these specific terrorism groups, Antifa groups that were named in this one, which those groups were Antifa Ost and let's see, German-based Antifa Ost, along with 3 other violent Antifa groups in Italy and Greece, especially designated global terrorist. Let me see, was it this one that gave me their specific names? Yeah, it's the Antifa Ost in Germany, and the Informal Anarchist Federation or International Revolutionary Front, which is based in Italy, but stretches out to other places. Armed Proletarian Justice, which is Greek anarchist and anti-capitalist group. And the Revolutionary Class Self-Defense, which is also Greek. So if they have any connection to those groups, it could then connect them and lead to more seizures of people in that network and investigations and maybe indictments. And one of the things that I keep thinking about in this case, and I don't think this indictment, one of the things that's frustrating about it is it's just an image scan. So I can't control F it. But there's a place here where it mentions materials. As in like there were like documents and propaganda materials that were seized at some point when they went looking for these individuals. And it was one of them who left, who wasn't arrested on scene. And when they went to go get him or her, there was like some boxes of propaganda and leaflets and instruction materials and things like that. And that sticks out in my mind as possibly something that could be traced back. Like these might be like manuals and other items that are circulated among these groups, and it's documentation of their ideology, and it might be something that's circulated from groups over in Europe to groups in the US. And I'm not seeing it immediately. There's the cell. I remember they had a number of firearms, and they've been doing training, and they have video of them doing this. They have a bunch of they have their chat logs, their cell phone, and their encrypted messaging apps. They have those unlocked, and they have access to all of them thanks to the people cooperating, and also thanks to the technology that they have. There's definitely something in here about material that they acquired when they arrested one of these individuals. And I want to say they had it in their vehicle, or they had it in the apartment they were hiding in. Do not see it. I do not see it. I should have looked it up before I started recording. Anyway, big update in this case is, and that's about the only update. I think I just dropped all the knowledge that I have on what's happened since I last talked to you about it. About almost a month ago was the last time I did a video on it, when the first superseding indictment dropped. There's been a little bit of back and forth on discovery, bill of particulars, and then there was the scheduling order, which I believe that was last week, and I believe it set January 20th as the trial date. And I just kind of thought that seems pretty soon. I don't think they're going to make it. And now that there's been a second superseding indictment, I don't think they're going to make it. Let's see. Trial. Where is it? It says January 20th somewhere, I think. This is an order about the scheduling and all the pretrial stuff they have to do and when they have to do this, but this is all probably going to change. The judge is probably like, oh God, now I just set a scheduling order last week. Now I got to set another scheduling order because you guys decided to drop a new superseding indictment. Anyway, okay. I'm going to check real quick and see if I can find any other Antifa related cases that have emerged since this one. Try and track down those other arrests that have happened, and then I'll come out with another video. Thank you for watching. Hit ko-fi.com or my other links if you want to support the show and keep me on this case and getting after these documents. Have a good one. Hey, look what I found. I went looking and immediately found United States v. Bowman. So that guy who had his name edited in that case, and he was indicted way back in July when he was first arrested. But then it looks like an information was filed November 13th, which is around the time that DOJ filed that superseding indictment in the larger case, United States v. Arnold, against the whole Antifa Cell. And this shows that a plea agreement was reached on November 19th. And if I go and read that plea agreement, just 9 pages. And let's see. He waives his right and pleads guilty to the offense in count 1 of the information, which charges him with 18 USC 2339A, which is providing material support to terrorists. So is this the first conviction of an Antifa member for providing material support to terrorists? It may be. The defendant understands the nature of this crime, blah, blah, blah. Maximum penalties that the court can impose are up to 15 years, a fine not over $250,000, supervised released, forfeiture of property, and restitution. Court has some discretion in sentencing, of course. And let's see, what else? There's the restitution part. Forfeiture of property. If it agrees not to contest that his property is subject to forfeiture under these statutes. Government will not bring any additional charges. Going to file a supplement in this case. Okay, so this happened. Looks like it actually says 14th, but I guess it's 19th, 2025. Okay. What is... Has there been a sentencing memo? No. No sentencing memo filed, so we will look for that. This is factual resume. We will look at this to see if there's anything in the sentencing memo about what he may have provided. Ooh. Okay. Very neat. Immediately, as soon as I conclude that video, I went and searched just Antifa and federal criminal cases, and bam, this came up immediately. There was another one for a guy named, there's another one in Oregon, but it's just threatening an officer. It mentions Antifa, but he's not charged with terrorism. And then there was another one in North Texas, which is Sykes. And there's this one, Sanchez Estrada. And I think both of these are related to the same case. The same, yeah, they are. They're both related to that ICE detention facility attack. And so let's see, is there a plea agreement in United States v. Sykes? Yes, there is. Same date, November 19th. And then let's see right here, is there a plea agreement for Sanchez Estrada? Oh, where's it at? There isn't. There isn't yet. Why is this guy being charged separately? It does appear, the date, July 7th, is around the same time as that attack. That attack on the ICE detention facility was July 4th. So, and this is the same district, right? Yeah, Northern District of Texas. So there's the seal complaint. I thought I saw an indictment. Here we go. What is the difference with this one? 4 pages. Oh, this is the person who helped hide. This is the one I was thinking of with the materials. Oh, look. Corruptly concealing a document or record. Okay, so they separated this, and this is the guy who was helping hide some of the Antifa Cell members. And he corruptly concealed a record, document, or other object, or attempted to do so to impair law enforcement investigation. He transported a box that contained numerous Antifa materials such as insurrection planning, anti-law enforcement, anti-government, and anti-immigration enforcement documents and propaganda. from his residence in Garland, Texas, to a location in Denton, Texas, intending to conceal the contents of the box and impair its availability for use to a federal grand jury and a federal criminal proceeding. That is count 1. Count 2 is basically the same thing. Conspiracy to conceal documents. This one was also corruptly concealing. Same statute, but different, portions of it. Between on or about July 5th and 6th, him along with co-conspirator 1 and others known and unknown, which are other members of that Antifa cell, concealed this material, and there was a conspiracy to do so. Sanchez, co-conspirator 1, and others known and unknown had that box of those materials. They moved the residence. They moved the box from one residence in Garland to one in Denton. Okay, so doing so and then conspiracy to do so because it was more than one individual. So these other individuals are either they're also charged in that United States v. Arnold case, or their cases are sealed or something. Okay, yeah, I'm pretty sure I recognize this name from the original indictment in United States v. Arnold. Okay, and this case is still going on. This person wasn't there at the July 4th attack, but he helped conceal some of the material and some of the evidence that would be used against them. So he's not charged with terrorism. Okay, and he hasn't pleaded. Okay, I'm still going to follow this just to see what happens with it, because evidence in this case could end up in our main case that we're tracking, United States v. Arnold, which I've lost in all of these tabs that I have open. Where is it? Here. In our main focus, United States v. Arnold, our terrorism case. All right. Now we know where that second indictment was edited. All right. Here's the end of the video. See you on the next one. Hey, just a quick update on the North Texas Antifa Cell. I know I just did a video on it and the second superseding indictment came out, but at the end of that video, I started digging around and I found some plea agreements that some of the defendants entered into. And then after publishing the video, I went back to it to try and kind of like track back some of the developments here. And I found more plea agreements. So if you recall, I think it was when I did my video on the first superseding indictment, or maybe it was the video right before, the government had made this motion to have the case designated as complex, which means that the speedy trial right stuff gets tossed aside because the case, there's so much information in it. There's so much discovery. There's no way that that the government can comply with the Speedy Trial Act. And there's no way that the defendant can be ready in time for trial either. So designating the case as complex just opens it up to everybody having more time, both sides having more time to deal with the immense amount of discovery here and structure their cases for trial, right? And prepare for trial. So as I was, or as you may remember, there were 15 defendants in this case originally, and 13 of those defendants agreed to continue time while they go through the discovery and engage in plea negotiations. But two of the individuals, like the two top guys in this Antifa cell, Cameron Arnold and Zachary Evans, did not agree. Well, through all of that, and this filing was back on November 3rd, okay? November 3rd, this filing came out, and this is where they tipped us off that, hey, we've gone before a grand jury, and there's going to be a superseding indictment here. And what we've done is we've gone to all the defendants and we've told them about this, and we're offering them, we've sent plea offers to all of the defendants, all 15. We've sent them plea offers. And the government prosecutors anticipated that a fair number of the offers will be accepted. For those defendants whom the government cannot reach an agreement, the government intends to supersede the current indictment, and they did. And they also said, we intend to add additional charges as well. This will increase the number of defendants in that indictment and add to the complexity of the case, which was another reason They wanted the case designated as complex, and the judge agreed to designate the case as complex. All right, so this was on November 3rd. They made this filing. Well, 10 days later, sure enough, 10 days to 2 weeks later, plea agreements start being filed. So let's see. The first one, this one says Nathan Bowman and Ben Flory Jr. agree to this plea agreement right here. And this one is Lynette Reed Sharp. And yeah, okay, wait a minute. I got it. I read the attorney's name. The attorney over here is Ben Flory. So Nathan Bowman, plea agreement. Lynette Reed Sharp, plea agreement. John Philip Thomas, plea agreement. Susan Kent, plea agreement. Joy Gibson, plea agreement. Rebecca Morgan, plea agreement. John Philip Thomas again, which I may have just clicked that twice. I think that's what I must have done. Let me get that off there. Seth Sykes, plea agreement. And then the last one, who I'm not quite sure what's going on with him. I think that they abandoned it. I'm not sure, but there's a separate case happening here concerning the defendant Daniel Rolando Sanchez Estrada. He was offered a plea agreement and he entered in. There's all these filings having to do specifically with him on his own docket related to this case. And he's got a motion to dismiss right here. So it may be they're trying to segregate or sever his case from the main indictment, but he is one of the people that it was ultimately hit with the superseding indictment and now the second superseding indictment. There's his name right there. He's defendant number 9. So it looks like he's engaging in a separate action with his counsel to try and sever his case or get some better plea agreement. Now, here's something I don't think I haven't seen mentioned anywhere, and I could be wrong. But remember, this is a terrorism case. The charges in this case are count 1, providing material support to terrorists. First time an Antifa cell, members of an Antifa cell have been hit with terrorism charges. And what did these other people plead to? Do you know what they pled to? I'll show you. Look what they pled to. Right. Oh, where'd it go? I skipped it. Man, I built up a moment and then I totally missed where it is. There it is. Defendant waives rights, pleads guilty to the offense alleged in count 1 of the information, charging them with a violation of 18 U.S.C. 2339A, which is providing material support to terrorists. Lynette Reed Sharp, what did she plead to? Where is what she pled to? Bam. Providing material support to terrorists. John Philip Thomas, what did he plead to? Providing material support to terrorists. Susan Kent, providing material support to terrorists. Joy Gibson, providing material support to terrorists. Rebecca Morgan, providing material support to terrorists. Seth Sykes, what did he plead to? Providing material support to terrorists. Are these the first ever convictions of Antifa members on terrorism charges? I think so. I think so. So that's 1, 2, 3, 4, 5, 6, 7. Just 9 more to go. It's like a great start to me. It's a great start to me on taking out this Antifa cell and making, remember, landmark case. First time Antifa has been defined in a court filing. They're defined in this indictment. And first time an Antifa cell has been, or members of an Antifa cell have been hit with terrorism charges. May it be the first of many. All right, see you in the next video. All right, so yesterday, FBI Director Kash Patel announced and linked to a Breitbart News article that detailed an indictment against a Black Lives Matter director who was over the Oklahoma City chapter of that organization. It's no surprise that an indictment like this has come along. It charges her with 20 counts of wire fraud and I think 5 counts of money laundering plus forfeiture. And it's no surprise that an indictment like this came out. There's been many problems with BLM. There's the obvious problems with it, like what it stands for, its ideology and the activity it engages in, but also in the loose way that it dealt with just doling out money and donations and cash to these chapters who then were supposed to use that money to bail out protesters who either couldn't afford it or to just to give them a pass so that they could get them out of jail and they could rejoin the protest. So no surprise that an indictment like this came along. It's long overdue. Now, I have the indictment, and if you would like to go through it with me, well, you're welcome to. There is I'll give you the short of it right now. As the summer riots of 2020 kicked off, this person, Tashella Sherry Amore Dickerson, I'm not sure if she says Amore or Amore, but Tashella Dickerson, who is the executive director, as I said, of the Oklahoma City chapter of BLM, Black Lives Matter. She had just $500 in her checking account. Early summer, late spring of 2020, she's got $500 in checking account. By that July, she had millions of dollars, some like $3.5 million. She had embezzled donations and grants meant to pay for the arrest of BLM protesters and used it for her personal shopping sprees, to buy a car with cash, a $40,000 car bought with cash, many real estate purchases, and also about $120,000 or more in just handouts to family and friends. The activity continued 4 years from the summer of 2020 all the way up until the fall of this year. And then now she's been hit with this indictment. Let's go through it. First thing that stands out to me are some of the groups that were donating to this organization. The Alliance for Global Justice, which we're going to call AFGJ. The Tide Center, yes, that is a component of the Tides Foundation. The Community Justice Exchange, CJE. The Massachusetts Bail Fund, MBF. And the Minnesota Freedom Fund, MFF. Now, why are bail funds in Massachusetts and Minnesota donating to bail protesters out of jails in Oklahoma City? Kind of weird that, huh? It's almost like there's some sort of network behind the riots and protest that went on throughout summer 2020 and have continued and popped up here and there ever since. It's almost like there's some sort of network of enabling, funding, coordinating where these things show up and the damage that they do to communities. I wonder if somebody can piece all that together into a grand conspiracy case. Would be nice. So these groups started donating to the BLM chapter late spring, early 2020, the BLM chapter in Oklahoma City. They gave them cash donations, grants, things like that, and it was supposed to go to bailing out jailed protesters. And then when those protesters either showed up for their court hearing and the bail money was returned, or they stepped up and paid it themselves, whatever happened with it, if the bail money that was put up by the BLM chapter was repaid to the BLM chapter, they were supposed to either return it to these orgs who donated in the first place, or use it to bail someone else out. Or in the case of, I think it was the Massachusetts one or the Minnesota Freedom one, they were supposed to use it for other charitable social justice causes, right? Anything, but it had to be charitable. It had to be tax deductible. That's the way I'm using the word charitable, okay? Now, the background on this chapter is, of course, that it was founded to promote race equity, which, in my opinion, is just another word for racialism. It's racialism dressed up as fairness. And racialism is a precursor to racism, and racism is what BLM is all about, not as advertised. That's not what they're about, but that's what they're really about. The net effect of groups like BLM is they just make people more racist. That's an argument or a discussion for a different day. Although registered as a domestic not-for-profit group with the Oklahoma Secretary of State, the BLM Oklahoma Foundation, Black Lives Matter OKC, and Black Lives Matter Oklahoma Association, all three of those groups, okay, collectively are going to be referred to in this indictment as BLM OKC. They were not listed as tax-exempt organizations with the Internal Revenue Service. Now, one thing that's kind of occurring to me is that I grew up near here. I grew up in North Texas. So I'm used to seeing OKC and thinking Oklahoma City. Some of you may not be used to that, but you are used to seeing BLM. So as I'm going through this, where I say BLM OKC, or where it reads BLM OKC, that's what it's talking about. BLM Oklahoma City. I should probably highlight what this really means. Notice, this is very important. These three groups, collectively known as BLM OKC, were registered as a not-for-profit with the state of Oklahoma, but they were not listed as tax-exempt organizations with the Internal Revenue Service. Now seems like a good time. I'm just going to go ahead and give you a little bit of foreshadowing here. That line right there, that BLM OKC was not listed as a tax-exempt organization with the IRS, is a moment of oh wait, I totally screwed that up. That was a very super pro moment from me. I had it muted. All right, let's try that again. It won't be as good as it would have been, but still worth doing. Okay, so continuing, Dickerson, our executive director. Dickerson has been an executive director with OKC BLM since 2016, or BLM OKC. I got them mixed up there. Beginning by at least late spring and early summer 2020, BLM OKC raised funds to support its social justice mission and to post bail on behalf of individuals arrested during protests arising after the death of George Floyd. It was a wonderful time, wasn't it? Ugh. Beginning in or about late spring and early summer 2020, BLM OKC also solicited grant funds from social justice organizations, including the ones I listed above earlier: CJE, MBF, MFF, Tides Foundation, all those. These grants and these donations were acquired for the expressed purpose of posting bail for individuals who were arrested in Oklahoma in connection with protest. BLM OKC continued to receive grant funds from these social justice organizations through at least May 2024. I don't remember a whole lot of riots that would have necessitated such a thing, but it continued all the way into 2024. Maybe it's kind of interesting. Maybe they expected more riots to happen during 2024 election season and they didn't. I don't know. But they kept putting up this money. June 10th, 2020, BLM OKC signed a fiscal sponsorship agreement with AFGJ. So we're back to 2020, June, 10 days after the riots have really started in earnest, or 2 weeks after. They signed this fiscal sponsorship agreement with AFGJ. AFGJ appears to be like one of the main groups that they were getting donations from. And I think, just reading between the lines of the indictment, may be the group that the IRS went to and investigated first, or the indictment chooses to really dig in on that relationship. I have no doubt that they looked at all of these relationships, but they tend to extract the most information out of the AFGJ relationship, okay? The primary purpose was to allow BLM OKC donors to receive legal tax deductions through AFGJ's status as a public charity. AFGJ agreed to accept grants, contributions, and gifts on behalf of BLM OKC. But of course, their understanding is the money is only going to be used to post bail, and when it's returned or repaid, it's going to be given back to AFGJ, or it's going to be used to bail more people out, or it's going to go to some sort of charitable social justice cause, some tax-deductible cause. AFGJ would segregate the donations into an account called the Project Fund, per the agreement. And BLM OKC agreed to use the Project Fund solely for legitimate expenses in connection with the project. BLM OKC agreed to complete an annual report that provided AFGJ with a narrative of how BLM OKC used the Project Fund. BLM OKC agreed it would not acquire any real property without AFGJ's consent. And AFGJ agreed that all grants, charitable contributions, and gifts received on behalf of BLM OKC would be reported as contributions to AFGJ as required by law. Remember, AFGJ is the one who has the tax-exempt status with the IRS, not BLM OKC. That's very important to understand. One of the key reasons why BLM OKC needed to partner and needed this sort of agreement from a group was they are not a 501c3 with the IRS, but AFGJ is. So they take the money, they distribute it down to BLM OKC through this project fund. Okay. And what is the project? Bailing rioters out of jail. So many words to say about that. During the 2020 summer riots, BLM OKC's fundraising took several forms. Donations made to BLM OKC through its website were directed to AFGJ as BLM OKC's fiscal sponsor. Donations made to BLM OKC through its social media accounts were directed to BLM OKC's PayPal and Cash App accounts, but also occasionally to Dickerson's personal PayPal account. Record scratch. I need a noise to play for a record scratch. Let's back up there. Donations made to BLM OKC through its social media accounts were directed to BLM OKC's PayPal and Cash App accounts, but also occasionally to Dickerson's personal PayPal account. Uh-oh. 4 years straight of funds being moved around through these entities to post bail for people arrested in Oklahoma in connection with the protest. 4 straight years. July 2020, CJE, one of those other groups, social justice groups, sends $4.7 million in grants to AFGJ for the benefit of BLM OKC. Summer riots are in full swing. Bam. Almost $5 million. Here you go. Bail those rioters out of jail so they can get back to rioting. The purpose of the grants was to support Black Lives Matter Oklahoma City in posting pre-trial bail for individuals arrested in connection with nonviolent protest for racial justice. Now, when you see the amount of money they spent on bail, you're going to wonder, these were nonviolent and their bail was $1 million? What? If any bail payments were returned back to BLM OKC, they were supposed to use those funds for 501c3 charitable or educational work. And then they could report that to AFGJ. Things are on the up and up. And by July 2021, BLM OKC was supposed to report on how funds returned from bail payments were used or would be used. Any portion of the grant funds not used for their stated purpose were to be sent to the Tide Center, which really, I think, is where the money's coming from for all this. Tides Foundation distributes to these other groups, these social justice groups. Those social justice groups then issue these grants and donations to these Black Lives Matter chapters, who then use it to bail rioters out. It's really orchestrated from George Soros' Tides Foundation and all of that junk and BS and social engineering, color revolution shit. That's what's really going on here. We all know it. Also in July 2020, MFF, the Minnesota one, donates $350K to AFGJ for BLM OKC to use to bail protesters out. Money repaid or not used is to be returned to the Minnesota Fund. In April 2022, the Minnesota Fund amends the agreement to allow all the money to stay with AFGJ and be used by BLM OKC to pay for bail for individuals in Oklahoma City who cannot pay for themselves. So, now it's not just protesters who are arrested. It's whoever's been arrested that can't pay for their own bail. Use it for them. In June 2020, MBF gives $300. That's the Massachusetts Bail Fund. Gives $300,000 in a grant to BLM OKC directly to support bails paid for community members related to the uprising of summer 2020. Bail funds returned can stay with BLM OKC to be donated to their further social justice work. In total, between June 30th, 2020 and July 28th, 2020, MBF, CJE, MFF, they paid at least $5.35 million to the benefit of this Black Lives Matter chapter in Oklahoma City. Counts 1 through 20 of the indictment are wire fraud. They cover the period of June 20th through October 2025. Dickerson diverted funds to her personal benefit and then falsely stated in reports to AFGJ that all funds received by BLM OKC were used for tax-exempt purposes. Dickerson caused return to bail funds belonging to BLM OKC to be transferred to her personal financial accounts and thereafter used those funds for the benefit of herself, her children, and her associates. She went shopping. Mama's got money. She needs new coats, new furniture, new TVs, a new car. As funds are being donated to BLM OKC to bail protesters out of jail during summer 2020, Dickerson is moving the funds to the BLM OKC PayPal and Cash App accounts and occasionally to her personal PayPal account. Dickerson would just move tens of thousands of dollars directly to her own account, her own PayPal account. Sometimes she would move, and like right here, she moved $32,000 all at once from the BLM PayPal account to her own PayPal. This time right here, she moved $79,000 from the BLM OKC's PayPal account to her own PayPal account, and then used it to make retail purchases, travel, for food, for furniture. And then other times she would just move it directly to her checking account. Like that one time where she moved $39,000 from the BLM OKC's PayPal account directly to her checking account. Between June 25th, 2020. Okay, between June 25th, 2020. I got my sidebar here jumped on me to the very end of the thread. I didn't want it to do that. Between June 2020 and September 2025, Dickerson moved more than $120,000 from her own accounts to her relatives and associates. She was moving this money to her own account, and then she would use her own account to give money to her daughter and her friends. Of course, that money wasn't hers, though. It belonged to the BLM Oklahoma City chapter. And something that I've already said, I'm going to say it again. When all this started, prior to any money being put into the BLM OKC's PayPal account, okay? When the balance of the PayPal account for this Black Lives Matter chapter was zero, Dickerson had $545.58 in her own checking account. That didn't last long. As soon as money started rolling into the Black Lives Matter chapter that she was in charge of, it started rolling into her personal accounts too. Dickerson also solicited donations to the accounts, to the BLM account, but then put them directly into her own account. That's another big uh-oh. She's soliciting donations to what is supposed to be a charitable tax deductible cause. People are giving money, signing grants, and thinking it goes to a tax deductible group and cause. So they're going to be making a filing saying they did that. But it's not going there. It's going to Dickerson's own personal account. And IRS is going to notice, and did. For a time prior to July 6, 2020, at the beginning of the 2020 riots, BLM OKC did not have its own bank account. So AFGJ moved the funds directly to Dickerson. Folks, she went from having $500 in her checking account in the spring of 2020 to having $3.5 million in her checking account by the first week of July 2020. Crazy. She did use some of the money to post bail for people. Don't criticize her too much, people. All right? Don't be thinking she was putting all the money into her own account, okay? That's not true. She did use some of the money for the purpose it was intended to be used for. Like 12 people. Yeah. She posted bail for about 12 people. July 2nd, she posted $800,000 in bail for 3 people. What are you doing that your bail is in the hundreds of thousands of dollars? Nothing good. When a judge sets your that bond up there in the 6 digits, you did something really bad, or are alleged to do something really bad, I should say, and should probably stay in jail. And if some other entity comes along and pays it for you, it incentivizes you to abscond. This sort of, like, I'm not going to go on a tangent, but I just want to say this sort of activity of these third-party groups coming in and paying people's bail messes up what the system is supposed to be for. It throws a wrench into it. I don't think I'm not sure it should be legal to do this. Because the purpose of that money is supposed to be that if you're going to get out of jail, you got such a charge that's so bad. Maybe you're innocent, but you've been charged with something so bad. A judge sets your bond puts up a bunch of money in order to guarantee you're going to keep showing up for court. That's the reason that money's there. That's the reason that we have bails, okay? Is because the judge is thinking, this person did something really bad, and if I let them out of jail, they may never come back. So I'm going to set their bond at $500,000 or whatever it is they set it at, because I want to make sure that if they do get out of jail, they have to put up so much money to do so that they're going to keep coming back to court so that they can get that money back at the end of this whole thing. And when a third party comes in and bails you out, you got no skin in the game. Well, not none, but you've been given a get out of jail free card and you're not going to come back. Or a lot of these defendants aren't going to come back. Some of them didn't. July 6th, let's see. No, it wasn't July 6th. All right. July 7th, she transferred $2.9 million from her own account to the BLM account. So at least she moved some money back. And then she got $2.7 million in cashier's checks and used them to pay the bond for 9 individuals. 9 people. $2.7 million for 9 people to get out of jail. And then she bailed someone else out for $1 million. Something's screwy here. In total, Dickerson received $4.82 million into her checking account and the BLM checking account, which she set up in July, of which she posted $4.5 million in bail payments. $4.5 million to get 12 people out of jail. She was supposed to remember, when this money comes back, she's supposed to return it from where it came, or continue using it to bail people out, or use it for other charitable, tax deductible causes. Well, 3.5 million of that 4.5 million came back. $1 million of it was lost because the person they bailed out didn't show back up. The guy with the $1 million bond, this guy had 2 criminal cases in Oklahoma County. Which is Oklahoma City. He had 2 criminal cases there. His bond was $1 million. She goes and pays for it, and he got out of there. He didn't show back up. Sometimes Dickerson put the repaid bail money into BLM's new bank account. But other times, about 3.15 million worth of times, she did not. She put it into her own accounts. Such as between November 5th, 2020 and May of 2021, in a 6-month period, she put $2.2 million of returned bail checks into her own checking account. She also went and got herself a new car, $42,000 for a Palisade. And she took herself and her friends to the Dominican Republic and to Jamaica twice. And she went on a shopping spree, tens of thousands of dollars at Nordstrom, Macy's, Amazon, Best Buy, furniture store, DoorDash, Instacart, food and groceries. She spent $50,000 on herself and her kids. Then she went and bought some real estate. $270,000 for these properties, $139,000, $121,000, $231,000. She didn't just buy one property. She bought 1, 2, 3, 4, 5, 6, 7, 8, 9. She had money, and she was spending it. It wasn't her money, but it was money she had access to. And she was not a high integrity person. Dickerson concealed the scope and nature of her embezzlement from BLM OKC by lying. Of course. Of course. She just told AFGJ, who she's supposed to be issuing these reports to, about what she's doing with the tax exemptable money, supposed to be using it only for tax exempt purposes. She just lied about what she was doing. All of her financial reports that she gave over to the AFGJ, who is the tax deductible 501c3 organization that she's getting all this money through, and then they're having to go to the IRS and file these reports. She just told them a bunch of lies. And that didn't work. That didn't work. Let's see. She just submitted false report after false report, which, of course, the IRS detected because AFGJ is a 501c3. So they're following up to make sure that this $5+ million that was supposed to be spent on tax deductible causes was actually being spent on tax deductible causes, and it wasn't. So that's counts 1 through 20. Now counts 21 through 25, straight up money laundering. She bought all those properties, and what she bought all those properties with that money, the bail money and the charitable work money. So she moved it from the organization that was tax deductible in Oklahoma City and was operating using money, had been authorized by AFGJ, who's the 501c3, to use this money for tax deductible purposes. She took it out of those accounts, put it in her account, and then she made real purchases, which is money laundering. Not sophisticated money laundering, but money laundering. And so now she's been hit with forfeiture. She's going to have to, upon conviction, forfeit all of those properties, the car, all of the items she bought, everything that they can trace to being purchased, which they're going to be able to trace it because she moved it into her account and then into her personal account, checking account, and the PayPal account. They have all the financials. So they're going to trace every single thing she bought. And she's going to owe a money judgment as well as have to surrender every single thing that she bought. And that's the end of that. Now I'm going to track this case just to see where it goes. But I'm not going to give it the dedicated attention and focus that I give like the James Comey case or the North Texas Antifa Cell case or Merchant or McGonigal or the J6 pipe bomber. I'm not going to pay attention to it that carefully, but I am going to track it for you guys, and I'll give you an update on where it goes from here. I'm glad to see it. I think that there's probably a lot of cases, dozens, if not hundreds, of cases like this that could be brought that tie back to those 2020 summer riots. And to me, the most, exciting, but maybe intriguing thing about this that I think kind of gets my mind worrying is that this ties to all of these groups who I think need a very, very careful examination. And hey, maybe through the IRS and FBI looking into this one BLM chapter and looking at the financials of the money that came from these organizations and how it was supposed to go back ultimately to this one very, very prominent one. Maybe more cases will develop. We'll find out. All right. See you in the next video. All right. Mic check 1, 2. Hello. Welcome. This is Just Human episode 354. All right. Mic check 1, 2. I have an update for you in United States v. Comey. There's been a hearing before Judge Cameron McGowan Curry. That's her name. I can't get my mustache right. No matter what I do, I can't get my mustache right. No matter what it does, it's poking me. Blah. Stupid mustache. So Senator Chuck Grassley has just put out some emails and what's called an electronic communication, EC. It's an FBI document they used. It's like an FBI memo. And this relates to a possible investigation or some steps that that an FBI agent attempted to make. All right, folks, I got an update for you in United States v. Comey. Monday, November 17th, 2025 was a pivotal day in the case of United States v. Comey. James Comey, through a motion to disclose and in a matter, Comey sells seashells down by the seashore. Comey spells 8647 and seashells out by the seashore. Okay, I think I'm ready. Terrorism charges brought against them. That case is called United States v. Arnold. And there's also been significant developments with that case. And that's what I want to talk to you about. That's what I want to talk about to you in this video. In the U.S. because even though it's not the first time that a member of Antifa has been indicted, it's the first time that a member of Antifa has been indicted and had charges of terrorism or in this instance, material support to terrorists brought as a charge against them. So if this case goes the way that DOJ would like it to go, it could become a template for future cases against violent members of Antifa and their support network. At the end of that video, I promised that I would keep following this case, United States v. Arnold, and damn it. Mic check 1 2. Hello, hello. This is going to be Just Human episode 355. Yeah, 355. All right, hey guys, I'm doing a short video because we just got some breaking news in United States v. Comey. There was a hearing today before the district judge, Judge Nachmanoff, and it did not go well for DOJ or Lindsay Halligan. Oh boy, this case may very well be dead before Thanksgiving. Now, before I tell you all about what happened today at this hearing, I want to show you. Oh, well, it would probably help if I had things ready. Hey folks, welcome. I'm making this video right now because there's just been some breaking news in United States v. Halligan, a case that okay, this run describing the second threat to this case actually involves more documents, more filings anyway, and it involves a different judge. So here's where the threat begins. Back on October 12th, after a scuffle, there had been a back and forth about the issue of discovery already. Mic check 1 2. Hello, hello. Welcome. This is going to be Just Human episode. Well, I guess I better check. Hey, what's up, folks? Hey, folks, I got an update for you regarding the unsealing of Epstein and Maxwell grand jury material. 3 judges have come out and approved, and this is not the button I meant to click. Okay, test. See how this looks on screen. Mic check. I should probably set this thing up on the right audio setting. All right. Why is the camera not working? Dad nabbit. Wait, did that get it? Did I fix it? Nope. Mic check. Mic check. Why? Okay. Now it's working.